Hey everyone, it's Arshawn. Today we're going to be talking about uncertainty of court systems, particularly if you want to litigate and challenge something. So if you're thinking about challenging something in court, you're thinking about possibly bringing a constitutional challenge. If you think that something's just not right and you want to get your day to be heard, we're going to talk some about the reality of the situation. So let me start by prefacing this by saying, I am all for people fighting for their rights. I am a big advocate of constitutional rights, fundamental freedoms, a free and open and democratic society. But I want to talk about the reality of the court system too. So I want to set a tone of reality and to make sure that you understand what you're getting into if you decide you want to have a constitutional fight. Again, they are important to our society. They are meaningful and they make a big difference, but they are full of work and they are not simple. So we're going to dig a little bit in today about what a constitutional challenge might look like and what it might do for you. So hang on one second here. We're having a little audio issue here. So if you're going to bring a constitutional challenge, you need to be ready to understand some fundamental things, which we're going to walk through, and be prepared to do the work. So as always, on the McBride Attorneys Law Show, my YouTube channel, we are discussing very generally the legal system and parameters. We're not going to be talking about people's specific cases, specific situations. Rather, this is going to be more of a general discussion and more of an understanding of what the law is so that you can make informed decisions. So if you decide you want to challenge a law constitutionally, we need to start with a fundamental understanding of the U.S. legal system. And it is a tiered system generally, right? We have two separate systems generally. We have a state system and a federal system. They look a little bit like each other generally. They vary from state to state, obviously, but in general, you have a trial court. You have an intermediate appellate court above that trial court, which can then review the work of the trial court. And then usually you have a Supreme Court, a state Supreme Court, or in the federal system, the U.S. Supreme Court. 1, 2, 3 tiers. So if you're starting a trial out in the U.S. system and you're in a state law system with 3 tiers, most states have 3 tiers, you actually have 4 tiers of litigation possible. You can litigate in the trial court. You can litigate in the appellate court, the intermediate appellate court, the Supreme Court of the state, or the state court of appeals, whatever the case may be. And then if you're not happy with what happened in the state and it's a question of U.S. constitutional law, then generally you can go to the U.S. Supreme Court. 1, 2, 3, 4 layers of review. It doesn't necessarily happen that way for reasons we'll talk about, but you're looking at a long road ahead of you. To start, one of the biggest problems a lot of people have is just because you like or dislike a law doesn't mean you can bring a lawsuit. So in some parts of the world, largely the European system and some others, you could actually litigate about a potential law. I don't like the way law is written. I don't think it's clear. I think we should challenge its constitutionality. And they can do theoretical cases about what might happen. Here in the U.S., generally, we have to have a case or controversy, which means something has to have happened. You have to have that law in action. You got arrested under that law. You're changing your actions based on that law. Something live has to be happening. So it can't be theoretical. It can't be they might use this law in the future. So that creates a big hurdle for a lot of people. And it's challenging sometimes even to get what we call standing, which means it's got to be you too that's impacted by that law, right? You can't bring a lawsuit just because you don't like the law. You can't bring a lawsuit because it theoretically might hurt somebody else. It's generally got to be hurting you or your organization, right? So there's got to be an actual problem, and then you've got to be somehow connected to the person with the problem. You can't just be like, I'm going to be a good citizen and challenge the constitutionality of the law in the U.S. system. You generally have to be affected by the law. And that's why lawyers that are interested in fighting for constitutionality, they've got to find plaintiffs. They got to find people that have the problem. Now, usually over time, people get paired off. But the person that's named in the lawsuit, the person who's fighting, the facts they're looking at, there has to generally be a case or controversy. It has to be actually something that happened because of the law that impacted them, that they're going to fight. And it has to be a real case, not a theoretical case, not a maybe might happen. And it can't be somebody just bringing a lawsuit trying to be good to society. It has to actually be the person impacted. All of this, of course, leads to another piece of reality in bringing a lawsuit, which is the cost of litigation. If you're going to bring a lawsuit, you've got to get a legal team, generally, right? For a regular person to bring a lawsuit, it's very cumbersome. These filings, as you can tell, are very technical. There's these unusual terms: case, controversy, standing. Which court do we file in? What claims do we bring? What claims don't we bring? What laws do we cite, right? These are challenging issues for even lawyers to deal with, much less a person who only deals with these issues occasionally. So we want to know up front that we're going to have cost of litigation. It may be expensive on multiple layers, right? We have to, if we talked about up to 4 layers of litigation to get all the way to the U.S. Supreme Court, if we're starting out in a state court system, we're looking at a lot of paperwork being filed, a lot of stuff going back and forth, and a lot of procedural things, right? So we talked civil procedure, which is lurking behind all of this, is there, right? That's your statute of limitations, filing deadlines. Which courts do you file in? Who has jurisdiction? What case, what's the level of review? So as we move through the court system, another procedural item is sometimes courts look at the entire case. That's what they call a de novo review. Sometimes higher courts only look at part of the case. You've got to understand that positioning as you're going through. So that becomes a big challenge. And we got to understand that, we may have to rework cases over and over again. So even if we fight the case in the trial court, that's generally going to have a hearing with a judge or a jury, witnesses, that type of stuff. Then we move into the appellate record, which is generally lawyers arguing, looking back at the factual record of the first trial. There can be lots of paperwork in those layers of reviews. And this means, of course, time to litigate. If you're not happy with a current requirement, you may get a hearing in a trial court fairly quickly if it's an emergency proceeding. But if you want to fight constitutionality and go up the chain, take it all the way to the Supreme Court, as they say, you're going to have to put the time in to go through the trial court, to potentially go through the state intermediate court, to go through the state Supreme Court, to break it to the U.S. Supreme Court. U.S. Supreme Court only has 1 term a year. So they kind of pick which cases they're going to look at. And we'll talk about that a little more in a bit. Once they pick the cases they're going to hear at the U.S. Supreme Court, then they get scheduled. They have arguments. And then long after that, the opinions get released. The U.S. Supreme Court system is usually at least a year. And that's after you've done everything else. So to fully litigate a case that you want to take to the Supreme Court, you may be looking at a 4 or 5 year process. Another thing that's important to understand as you go through this litigation process is the courts will be looking at multiple claims generally, right? Very rarely does a lawsuit only focus on one issue. Usually there's a lot of issues going on. There might be a law that somebody doesn't like. There might be an enforcement they don't like. There might be wording they don't like. Of course, there's going to be procedural issues. Who filed when? Where did they file? All of this soup gets mixed together. And any one of those issues could come to the front. A court may decide, perhaps the case was filed by the wrong person, not have standing, gone, start over, go back to zero. They may pick up on a different issue than the one you want to litigate, right? If you're interested in litigating about a fundamental right, I've been doing a lot of work with the Florida Freedom Keepers and done some videos here on McBride Attorneys Law Show about, constitutional review, particularly in light of forced medical procedures. Those cases could get thrown out on something completely unrelated to medical procedures. Here you are fighting through the Supreme Court, wanting to get a ruling and getting guidance for the future, and maybe change the understanding of constitutionality of a law on medical procedure, and you might get caught up in a procedural issue that the court weighs in on. Or there might be another law that gets brought to the front that's not the law that you want to litigate. So with these multiple issues going on, when you read the opinions as you get higher and higher up in these appellate courts, they sometimes pick issues that you didn't think were going to come to the front. So there's a lot of uncertainty there. When you get to the top, let's say you do make it to the U.S. Supreme Court, which is often the goal, right? People say, I want to fight in the U.S. Supreme Court because if the U.S. Supreme Court makes a ruling based on the U.S. Constitution, it should be final. That should be an interpretation of that piece of the U.S. Constitution. So people love to get to the U.S. Supreme Court to fight U.S. constitutional issues because that should apply to the U.S. Supreme Court. The state courts and the federal courts should uphold it as respect of that U.S. federal Constitution issue. It's kind of the gold standard. You want to get there. So if you get to the end of this long road, you still have a lot of uncertainty at the Supreme Court. We talked about that filing system. It takes a while. First, the U.S. Supreme Court decides whether they're going to take your case or not. They don't take every case. Sometimes they just say, no, we won't hear that case. They have optional jurisdiction in most cases that come before them. So a lot of times issues will keep coming up again and again and again before the U.S. Supreme Court will even pick up and hear a case and issue a ruling. A lot of times they just don't get involved, and we're then stuck with those intermediate courts and their rulings, thinking about what the Supreme Court might do. When you do get to the Supreme Court, let's say you do make it there and they picked your case for hearing, then we have a lot of open items. We don't know what questions the justices are going to ask. Usually there's to be an oral argument, which means the lawyers go actually physically to the Supreme Court and talk to the justices. There's briefings, there's filings, there's paperwork go in there. Everybody looks at all of that. And then there's live time where the justices are sitting behind the bench and the lawyers are presenting and the justices are firing off questions. And if you've listened to U.S. Supreme Court oral arguments, the questions can be all over the map. And a lot of legal scholars will spend a lot of time after the hearing trying to figure out the bend of the questions. What were the justices trying to determine when they were asking questions? Which way are things leaning? A lot of uncertainty in the questions that you'll get. Then that goes into the Supreme Court. They do their process, and they'll issue usually an opinion. That opinion used to come back. If you look at the older Supreme Court cases, it would usually come back and say the Supreme Court says this, and you would have, a vote. There's a vote between the 9 justices now. It was less before, but usually they'll vote. Somebody will say yes, somebody will say no, and they used to get opinions together by the majority, where it was really the voice of the entire Supreme Court. More and more, those opinions come out fractured. 2 judges said this, and 3 judges said that, and another one said this, and then one dissented because of this. One agreed in part and disagreed in part. These opinions can be very difficult to put together and very hard to get guidance from. So even if you make it all the way through, you get your questions. Even if you win, you may get something from the Supreme Court that gets you a resolution of those facts and circumstances you brought before them, but the guidance they give for the particular issue that you wanted to fight to the Supreme Court may not come out the way you want. They also may step aside of the issues, and this happens a lot of times. Because there's so many issues in a typical lawsuit, you might want to get an answer on something, and the Supreme Court may not answer that question. They may guide their judgment on something else. So you just don't know. And sometimes they'll deem a question to be political. And if it's not a legal question, it's a political question. It's about the Congress, the state legislature, political bodies making decisions. And sometimes they'll just say, hey, this is not about the Constitution. This is not about the law. It's about politics. And they'll say, go talk to your congressperson, go talk to the legislature, go talk to the executive branch and get the law rewritten. So you just don't have a lot of certainty. It's something, if you viewed my video on Florida's forced vaccine law here on the McBride Attorneys Law Show, you can go check that out. That video, Louis Leo talked about that. We had some back and forth among attorneys and just talked about how uncertain things are. So if you're going to go all the way to the Supreme Court, you're not even certain you're going to get an answer. You're not certain you're going to like the answer. And you may not be happy with the outcome. You may not even get an outcome. You may often get lost somewhere along the way and never even make it to the U.S. Supreme Court. So that's important to understand. This is not to dissuade you from bringing a case. This is to tell you it's a long road and a long journey to prepare for. It is something you need to do the prep for. You need to be ready to run, and you need to have the fuel to make it the distance. I hope you're subscribed to the McBride Attorneys Law Show on YouTube. I hope you've rung the bell for notifications. Love your comments, questions. Drop them to this video. Let me know what your questions are, any clarifications you want on this video. and also what topics you want in future videos. I'm looking forward to reading your comments, hearing from you. I'm Shawn McBride. I'm signing off. I'll see you again very soon. Make sure you subscribe to the channel. We're doing some live events and other great things, and I want to see you there.